Good morning, and thank you very much, Dr. Greenspan, for those wonderful words to kick off our discussion today. This panel is entrusted to explore with this conference is independent courts as a precondition to, or at least an element of, open markets. We have a wonderful set of panelists here who explore this general question from both a global and practical perspective. In particular, our panel will ask the question and hope to explore with this audience, how does the independent judiciary particularly impact business and the world of commerce, and taking it from a global and practical perspective that they bring into the question that's posed. We will start with C. Boyden Gray, a person who is familiar to this conference and many in the room. He is the United States Special Envoy for European Union Affairs and also the Special Envoy for Eurasian Energy. Prior to this appointment, he served as the U.S. Ambassador and representative to the European Union in Brussels. And of course, he was a partner at the local law firm of Wilmer, Cutler, and Pickering, now the global law firm of Wilmer Hale. He, of course, served as legal counsel to President George H.W. Bush, Bush 41, and earlier as his legal counsel as vice president. Boyden was born in Winston-Salem, North Carolina. He earned his bachelor's degree, magna cum laude, and J.D. from the University of North Carolina at Chapel Hill, where he served as editor-in-chief of the Law Review. He served as law clerk to Chief Justice Earl Warren, Supreme Court, in the term of 1968. Boyden?
Thank you again, Justices O'Connor and Breyer, for the privilege of being here, and Georgetown Dean, Justice Souter. This is a big honor for me. I want to clarify that that my last dinner back for vacation was to be at the house of a General Leakey, who is the British-born head of the European Defence Force. Diplomatic title, since there isn't much of a European Defence Force, at least not yet. But I couldn't go because I was trying to pack up. But he very kindly sent me a guest list on which I'm Gray, U.S. Special Convoy. What I want to talk about is just some basic facts about the founding of our own market, which is really the creation. I said something like this at the last conference, and I'm now sort of repeating myself, but it is important to remember that what forged our internal market was the Supreme Court. Hamilton and Washington put Marshall there in part this court in order to depress the state interference, member state interference with our interstate commerce. Much of the current lore about judicial independence stems from the desire in those days that the Supreme Court and the lower courts had the strength to do what politicians were inhibited in doing, which is to tell local monopolies supported by the member states butt out and let the general marketplace prevail. This, of course, Congress and the lack of an internal market that bedeviled Washington as much as it did the lack of executive authority. So our market is owed to Justice Marshall and a little device known as the Dormant Commerce Clause, known only to probably in this room, but to some of us a very important document, a very important development, not in the Constitution, by Justice Marshall. Yet Dinh and I had occasion recently to litigate about this issue, so that if you think the Dormant Commerce Clause is dormant now, you would be wrong, because it just permitted wine to be shipped interstate not too long ago, a case that was by the Supreme Court. So the Dormant Commerce Clause is not even dormant, but it has been an enormous contributor. Paul Johnson, the great historian, called it the greatest act of judicial statesmanship in modern legal history. The European, in contrast, does not have the same centralized judicial capacity to enforce this. Much of the common market that they have is, in fact, a creation of the Court of First Instance, enforcing the pillars of the European Union, the free movement of goods and services, but it is not complete. And Europe now is bedeviled by fragmented, causing them extreme anxiety, especially with Russia's resurgence around their borders. The Georgian incident is just another example. Europe has problems in other realms with having a fully realized internal market. And this is something which costs them maybe a point or two of economic growth, which, of course, affects us because we have such a deep trading relationship with them. For us, the Dormant Commerce Clause receded in importance as the federal regulatory state grew, but we adopted a thing called the Administrative Procedure Act, overseen by the D.C. Circuit, often referred to as the second most powerful court in the United States. In Europe, there is no analog. There is no D.C. Circuit. If you are affected by a judicial ruling, by coming out of Brussels, you are not able to get into court if you have anybody else who's affected with you. It sort of turns our rules of standing on their head. The more widely impacted the group affected by a rule, the less chance to get into the EU court system. Only if you are a Microsoft or an Intel or a Qualcomm and you are singularly bedeviled do you have a chance to get in. And even then, the rules are rules of great deference to a finding system, a system for making these findings, which is not as administrative law judge system in, say, the Federal Trade Commission or other. What the D.C. Circuit does, in my view, after 30 or 40 years, in Washington is enforce procedural playing field, no favoritism, transparency, so that one group cannot be seen as taking advantage of another group, at least not using the government to do so. And again, the European Union doesn't quite have this system, and that is why, again, their energy markets are fragmented. We are very lucky, I think, to have a court system that has created our central market, our internal market, and that has enforced it, created a huge regulatory state. And we are lucky. We'll eventually get there. They're only 50 years old. We're the old country. I say to Europeans, I'm a North Carolinian. My state is older than half the states of Europe, older than Germany, older than Italy, older than Belgium, and we're the old country, and you'll eventually get to where we are. So thank you.
Next up, we're fortunate to have Brad Smith, who is Senior Vice President and General Corporate Secretary for Legal and Corporate Affairs of the Microsoft Corporation. He leads the Legal and Corporate Affairs, which is responsible for all legal work in government, industry, and community affairs activities. He also heads its foundation, more importantly. Leading role at Microsoft on intellectual property, competition law, and other internet legal and public. He's also the company's chief compliance officer. Since becoming general counsel, he has overseen numerous negotiations, sometimes litigations, with government, including Microsoft's 2002 antitrust settlement with the state attorneys general and the 2002 data privacy negotiations with the FTC Commission, and agreements to address antitrust or IP issues with Time Warner, Sun Microsystems, Real Networks, IBM, and Novell. Before starting at Microsoft, Brad was a partner here at the law firm of Covington and Burling, working both in Washington, D.C. and the London offices, and represented a number of companies in the computing industry. He graduated summa cum laude from Princeton, where he was the class of 1901 medal, and the DeWitt Clinton Poole Memorial Prize and the Dodds Achievement Awards, and so many other awards that we don't have time to name.
Good.
He was a Harlan Fistone Scholar at where he received the David Berger Memorial Award, and he also studied law and economics in Switzerland. Brad?
Well, thank you. I'll speak from here, and I thought I would just use a few minutes to build a little bit on what Boyden said and highlight really two things. The first is the practical role that access to the judiciary has for at least us in our industry, and I think many other industries, in terms of building and getting access to markets. And second is to give you a bit of a perspective on the practical problems that one encounters around the world today. Software is an interesting product. It takes a lot of money to create, and it takes no money to copy. And so if you actually want to get access to a market, the first thing you have to do is go build it. And you go build it by basically, first you invest in training people so that there are technical support engineers and the like who can work with governments and institutions to deploy software. And second, you establish the fact that if people want to copy it, they actually have to pay for it. And the way you do that is by getting a law passed and showing that it is, in fact, enforced. When we started doing this as an industry 2 decades ago, we actually did discover the countries that had no copyright. We referred to those countries as one-disk countries, because in each country you'd ship in the first disk of software and you'd never ship in another. Everybody had it, they just didn't pay for it, and they didn't need you to provide any more legitimate copies. Literally in most countries, when we would first invest, the software piracy rate would be well above 90%. So over the course of 2 decades, we basically have gone from country to country, first in developed markets, now literally around the world, to try to establish and enforce these copyright principles. During the last 12 months, we at Microsoft have filed over 4,100 cases in just under 70 countries. A fairly typical year. It gives us a very good window on the world, a perspective on how the judicial system is working. Unfortunately, in many parts of the world, it doesn't work nearly as well as one would hope. And the myriad of problems that one must confront is really as diverse as the world itself. It starts in countries or regions in countries where, frankly, there are no lawyers. It goes to countries where there are lawyers, but the lawsuit is a dangerous proposition. It's dangerous to witnesses. I can recall a courthouse in a major capital in Asia where witnesses, in our case, twice in the last 18 months, were virtually hurled down the staircase in the courthouse itself by the defendants after their testimony was completed. There are many places in the world where it is dangerous to be a lawyer. We turn up for meetings thinking that they were there to settle a case, and instead threatened, they have been assaulted. In some cases, they've been beaten up and quite severely abused. There are many, many places in the world where one brings a case, gathers the evidence, entrusts the evidence in the physical custody of the police officers, only to find on the morning of trial that it's just not possible to find that evidence anymore. The problems extend to the role and the nature of the judiciary itself. There are a number of countries where there just aren't enough judges for the judicial system to operate effectively. In India, it typically takes 12 to 15 years from the filing of a copyright case relating to software just to the judgment at the district court level. We've filed over 75 lawsuits in India over the last decade, and of those 75, only one has now reached the point of getting a district court judgment and is now on appeal. There are many countries where judges are so underpaid that there is an incredible temptation and pressure on them to supplement their income by resorting to bribery. One can talk about markets and the judiciary. I know of a country in Eastern Europe where there is a market for the judiciary. everyone knows that the market price for a judgment in this country is roughly $1,000. If you bring a case, you can get someone, a defendant, to settle with you if you're prepared to accept a settlement of less than $1,000. If you want more than $1,000, they will simply pay the judge instead. And these risks are rampant in many other parts of the world as well. And even in jurisdictions where there are enough judges and they're sufficiently paid, there is great pressure that many judges feel to defer to the power branch. Whether that power is manifested in a case against a large company or it's a case involving a local police officer who is supplementing his income by extorting bribes from poor people based on trumped-up charges brought against them. If you look at the world today, I think it ultimately calls on us to ask ourselves, what does all of this mean for us? I think first, it is important to recognize how exceptional we are to live in a country that has a 2-century-plus track record of an independent judiciary. An independent judiciary that, by and large, most of the time, it is much more exceptional, I think, than most. Second, it's important for us to appreciate how significant our work is in maintaining this judiciary for everyone else who works in or is connected to the judiciary around the world. There are great everywhere. And for the most part, people who aspire to become judges, in fact, aspire to become great judges. But they don't necessarily in an environment where that is easy or even possible. And the example set here is of tremendous day-to-day significance in helping them independence of the judiciary where they live. Finally, because what we have is not only so important but so precious as well, I think it really does call on us to be almost hypersensitive in addressing the problems here when they arise. Ultimately, one of the lessons I've learned from this experience is that the time to address problems is before they become so large that they basically become unsolvable. We are very fortunate that our problems are not so large that they have become unsolvable. But we should be very sensitive to a situation where we start to inch backwards, because this is a classic example of a problem where if you give up a few inches, very soon you're finding that you've fallen back a mile. So I hope that that's the kind of opportunity that we have today to focus on here in the United States and how then in turn we can help others around the world. Thank you.
Thank you very much, Brad, for those very sobering thoughts, but also hopeful remarks. Next is Kenneth Frazier, who leads Merck Incorporated's Global Human Health Organization, serving as its executive vice president. He also serves on the firm's executive committee, which, as you know, makes all the strategic and managerial decisions for the company. Ken joined Merck in 1992 and has steadily climbed the corporate ranks there. Before that, he was a partner at the Philadelphia law firm of Drinker, Biddle, and Reed. In December of 1999, he assumed the position of Senior Vice President and General Counsel, overseeing Merck's legal and public affairs and the Merck Company Foundation. He was promoted to in August 2007. He's a member of the Council on American Law Institute and the American Bar Association. He received his BA from Penn State and his JD from Harvard. Ken?
Thanks, Viet. Good morning. I want to say, like many of the other panel members, that it's quite an honor to be here. Justice O'Connor, other justices of the Supreme Court, Souter, Justice Breyer, assembled people. It's wonderful to be in a place like this today. This is no ordinary gathering, and it's quite an honor. Like Brad's business, our business is based on the fundamental notion that innovation, in our case stemming from large and sustained investments in pharmaceutical and vaccine research over protracted periods of time, will lead to significant improvements in the health of people around the world. A company like ours cannot even begin to consider making the large upfront investments necessary to pursue the discovery of new drugs and vaccines. I will say on average $1 billion for every product that comes to market, unless we can believe that when we are successful, that we will be able to bring it to a market in which we will understand clear and transparent rules, that they will have predictability of what IP rights can be enforced, where there will be accessibility to the courts, and finally, impartiality. Like the software business, the cost of producing drugs is very cheap relative to the cost of discovering them. It is not that make drugs expensive. It is all the years of research and development, regulatory approvals that really cost money. We do business around the world, and around the world there generally are few places where there are free markets for health care. Put differently, most governments around the world consider the provision of health care to be a basic responsibility of the government. And so our customer in most markets is in fact the government. And we encounter issues with respect to the government as a customer negotiating prices, while at the same time we're subject to administrative agencies who decide, for example, in the instance of health ministers, whether we can have access to the market, under what circumstances, for what uses our drugs will be used, at what time they can be brought to the market. There are people who are obviously in charge of policies. There are people who are interested in industrial policy. There are agencies that are in charge of IP protection and enforcement. And lastly, there are competition authorities. So in doing business in these markets, one has to deal with different administrative agencies that have very different policy perspectives and very different needs. While at the same time, and I won't repeat everything that Brad said, access to the courts, timely access to the courts, is something that's extremely difficult in most markets. If you have a product on the market in India, for example, there are many people in India who are copying products very quickly. It will probably take you 12 to 15 years to get a case to trial in India. So even if there are laws on the books that protect you, national laws, or even signatory to World Trading Conventions under the WTO, for all practical purposes, there is no enforcement. Now, since we've had the conversation about IP, I'd like to shift to talk a little bit about the U.S. court system and our experience in the U.S. court system in the context of products liability. A few years ago, Merck withdrew one of the largest pharmaceutical products in the world, a product called Vioxx. And when we did that, we were engaged there in one of the largest in history. It was the subject of a great deal of interest, a great deal of media attention. I say in my lower moments that we were in fact convicted on the front pages of all the newspapers in the United States before we ever got to court. And there were 60,000 Vioxx lawsuits filed. And the conventional wisdom at the time, as expressed particularly by the financial community, was that we should not litigate these cases because of the unpredictability of the U.S. court system. People said you will be forced to try cases in jurisdictions where the defendant can't. That these cases raise issues of complex biomedical research issues that lay juries will not possibly understand, that the sheer number of these cases will cause the company to break down and not be able to defend them. And we actually decided, in a situation where we were extremely vulnerable, many commentators thought that the size of this liability would in fact make our company bankrupt. There were estimates of $50 billion and $45 billion. And we decided that we believed in the U.S. court system and that we were going to ask for our day in court despite what the public impression was of what the conduct had been. And we were able to take our cases to courts, and what we were able to find, for the most part, is that juries were very sober and took very seriously these issues. And even where you had juries where not one person had a college education, they were very scrupulous about listening to this evidence. On average, these trials take 2 months, and they're extremely complex. But what we saw, sworn to do their jury duty, were really taking those obligations extremely seriously. We saw for the most part that trial judges wanted to do their jobs of screening the evidence that went before those juries and dismissing cases that should not have gone there. When we found instances in the trial courts where we believe we did not get a fair shake, we found that the appellate courts were willing to step in and make the kinds of rulings that we needed, even in those areas where there hadn't been extant law before. If there was one thing that we learned in this litigation, and I think that's extremely problematic, it is the capacity of the courts to deal with these problems. While those cases that were tried, we had relatively good experience, the fact of the matter is the current court system can't deal with this kind of large, protracted litigation. And unless, and I want to echo something that Justice Breyer said last night, I think one of the first and fundamental judicial pay, but we also have to provide courts with the resources that they need in order in these kinds of cases. In the end, frankly, one can't try too many of these cases. We were fortunate enough to be able to try 17 in a 2-year period, and the courts were able to help us fashion an effective settlement. So I would just conclude by saying really disparate experiences with litigation that is central and important to the future, not only of our company, but to the future of health all over the world, since it's private capital in research that creates all the advances. It's the advances that we hope for in Alzheimer's and cancer and in many other fields where we have intractable human conditions. So we saw very different results depending on whether we were litigating in the U.S., whether we were litigating outside the court. And like Brad, I would say that, and I echo what Dr. Greenspan said, are very fortunate to be in a system where we have a reasonable degree of predictability and transparency and timely access to our courts. So thank you.
Thank you very much, Ken. Let me start by reminding everybody that this is a conference, and we encourage, indeed, Justice O'Connor expects your questions and comments and sharing your experiences, because that leads to our common understanding and enlightenment. So there are microphones right on either side, and we will recognize you as you have. Let me start off the discussion by picking up on a point that Boyden made. A lot of us that there is no EU version of the D.C. Circuit, and yet so many of the business of the people in this room, in particular for Brad and Ken, depends upon the decisions of regulatory agencies. And let me start by asking Boyden, what is the substitute, however imperfect, for D.C. whims and arbitrariness of regulatory agencies in Europe, and then turn to Brad and Ken to see whether, in their experience, it is an effective.
Well, you have to start in the member state courts, which is at the outset problematic, because those courts are going to defend, that's why we have diversity in this country, because we don't want the states holding forth on issues that involve their own constituents. And so that's a problem. You can eventually get into the European court system. It takes a long time. The record is not the same, and it's just not done very successfully or very often. You can get into the court directly if you're singularly affected, as Microsoft was, but the judicial rulings or the administrative rulings that lead to this review do not have the kind of refined administrative law judge procedural regularity and predictability that our administrative law has in this country. One of my worries is that we'll all wake up 10 years from now, and there'll be a headline in the business section of the Post that says Judiciary Committee reduces D.C. Circuit to 3 judges. Now, why do I say that? Because Europe is going to be the default regulator, unless something is done to halt the current trend. Because they have the largest consumer market, and because supply chains are so interrelated, they will set the outer boundaries of regulation. They're doing it now in chemicals. They do it for antitrust enforcement. They do it for privacy rights. They do it for GMO foods. They do it for agriculture generally. It's just just beginning. Want to sell your goods or make your goods internationally, you have to comply with Europe, and they know that this is one of their strongest exports, their regulatory regime. And so, in some ways, the D.C. Circuit may be rendered irrelevant because the rules will be set in Brussels with no D.C. Circuit to oversee it. It's a little chilling.
Well, I think there's two aspects that are worth noting. First, more and more in the world, decisions are made in administrative proceedings, and then there is the principle that the courts will largely defer to the proceedings unless a high standard is overcome. And yet, in most of the world, there is not really a well-established body of administrative law. I think the United States literally is almost unique in terms of the body of administrative law that has emerged. So when I get to a place like Europe, my first wish would be to see administrative law exist in a more fulsome state, or at least reflect what was put in the Magna Carta. If we could just get what was in the Magna Carta established in administrative proceedings, it would be a lot easier to defend one's rights, especially when one is facing high-profile cases and potential property, in this case, intellectual property rights. The second thing that I wish every day people in Europe would remember is that Montesquieu was French. The notion of a separation of powers is not a uniquely American idea. It actually was born in Europe. And yet, I think in practice, it doesn't prevail in a great many countries, even in continental Europe. It's difficult for it to prevail when judges are appointed by the executive branch for a relatively short period of time. I think one of the great beauties of our Constitution is that it not only established the judiciary as an independent branch, but it appointed judges for life. That's, I think, one of the keys to having a truly independent judiciary.
Well, I won't repeat what Brad just said. I'll just say that to litigate in administrative agencies where you have limited rights to participate in the actual development of the factual record, where the basis for the decision, frankly, is not very clear. The rationale for the decision is not very clear. And in fact, the time through which the decision is made is often takes so long that you actually get regulated by default. Because in our case, we're trying to affirmatively enforce IP rights, and it's the inability to get a decision, frankly, that makes your IP rights sort of wither on the vine. So I think those are the issues that we deal with. I think it's also while we started off talking about the EU and the U.S., how important other nations are in the world. In the year 2016, 25% of the pharmaceuticals that are used in the world are going to be used in places like in India. China now has a middle class that is larger than the entire population of the United States. And so there are a number of becoming critically important, particularly in businesses like ours, where they only have nascent legal systems, where they're only beginning to contemplate what the rule of law is. So those are major issues too.
Let me continue on this train of thought, especially since Boyden touched on administrative. And you both talk about the judges in general. You know, the big conversation that we're having in this conference for the last 3 or 4 years and continuing in this country with the ABA and everybody else is the selection of judges as between appointed merit selection versus elected judges. Now, if you put in the European example, and especially the civil law system, you know, there are professional judges where you know, you come out of law school and you track toward becoming a professional judge. I was wondering, taking all of those various perspectives that you all have, what is your judgment, however uncertain it is, as to what is the preferred selection of judges, and it may be, you know, a combination or context specific?
Well, I'll take a shot at that. And most of my views have to do with the way in which I perceive the state court system to be working in the United States. I would say that I think the discussion of selection versus election is not really the issue. From my perspective, there can be electoral systems that work fine and selection systems that don't work particularly well. I think the question is whether or not judges are selected in such a way that they can be insulated from the people who are actually selecting or electing them. It matters whether or not the process by which these judges are elected or selected is one that focuses on their capabilities and their temperament to be judges as opposed to their willingness to deliver a desired result from a constituency standpoint. So, for example, I know we're going to talk about this later today, the phenomena that we have in the United States right now where corporations and plaintiffs' lawyers are funding judicial elections at very, very large amounts of money is something that I think we all agree doesn't inspire a huge amount of confidence on the part of the public. It's a necessary evil. I will tell you, I have engaged in those races because I understand that the candidates on the other side are being funded by people who have interests that are antithetical to what my clients' interests were when I was the general counsel. So I would say at the end of the day, I think it's not a question of selection or election. What are the grounds upon which judges are being selected for their positions, and whether or not they're in fact sufficiently insulated, particularly from government authorities, so that Article III courts do every day, which is decide whether or not the exercise of authority is consistent with the constitutional limitations that are placed on that government.
I think a lot of this does come down to having a selection process that not only attracts and appoints or elects people, but ensures that they can be independent once they start to serve. And I therefore think one of the questions one should keep in mind is how long people get to serve. The shorter, more subject to influence simply because they're going to have to do something to keep their job. They're either going to have to persuade the executive branch to reappoint them, or they're going to have to persuade the population to reelect them. Personally, I don't think that there's any system in the world that can match our federal judiciary, with the possible exception of some of what we see in the United Kingdom and the like. But the model of appointing people, appointing them for a lifetime, and hopefully, even though we're not doing it today, giving them enough money that they can afford to serve for the rest of their career. I think that is the role model, and the closer we can come to emulating that role model, the better off we'll be.
Boyden, you and I have worked on the selection of federal judges more often than we would care to admit. Do you have a particular perspective, especially as it relates to, the issues that we're talking about here, business and commercial issues, which rarely, if ever, in my experience, has surfaced in the confirmation process, at least not in the controversial ones, and yet it is so important to our society and to certainly the people in this room?
I don't know what I can add to what's been said. I have a sense that the federal system will take care of itself. Of course, judicial selection is obviously controversial, difficult, but we somehow manage to get through. I worry more about the state system, about the election, about the campaigns that get run, the money that gets spent. I don't know what the answer is, because most states use the election process. My home state does. And I don't know how you're going to change that. I suppose it helps on some instances to strengthen the diversity rules so that some of the tort litigation that should be brought into the federal system could be. We've seen some reform in this sense. I think also, shareholder litigation gives shareholders more of a choice about whether they want to go through the courts or through some sort of arbitration would help. But I don't have an answer to the judicial campaign problem in the state courts.
Well, let's turn to that state courts the issue then. I must admit that Ken's remarks was very, very refreshing, because quite often when you hear general counsels talk, it's a common refrain. An explosion, tort reform, and how the system is breaking down. You actually give an example of Vioxx where, at least from one participant's perspective, the system worked fairly well in resolving the disputes and the like. Let me start back with Boyden. Where do you see tort reform in general, the heading as you step back into Washington, D.C., and then maybe ask Brad and Ken to comment on both on the product's liability side and also on the IP side, because we all know specific jurisdictions in the country where those are part of the flavor du jour for runaway jury awards.
Well, I'd like to kick the ball back to Merck because you have much more experience with this problem, and I think your Vioxx experience is very useful, and you've already described that. But I'd kick the ball back to you in terms of how you manage this.
Well, as it relates to tort reform, there are obviously states and jurisdictions in this country where I think one can look at empirically what the results are and recognize that there are some issues. I would like to not name those states since my son is complete, but not 100%. But I do. At the end of the day, it does come back to the issue that we're here to talk about. I think if we have an impartial judiciary, which starts with the selection process, and people are able to have sufficient tenure and sufficient pay and sufficient incentives, that's the only system that we're going to have. And I think in our experience, even in those very difficult jurisdictions, we decided that we were going to trust the entirety of the system, not just what happened in the trial court or in the jury context. We were willing to take cases up on the courts of appeal. And we were able to find that there was a certain amount of tort reform in the system by being willing to trust the checks and balances that are inherent in the state court appellate system. Is it a perfect system? No. Am I here to say that I would like to go through that experience again? No. It was really a life and death experience. I just wanted to say, though, that the commentators who urged us to opt out of the system at the beginning at great expense to avoid the unpredictability and arbitrariness of the system were not correct. We were able to go through the system, and we were able to get justice. And I think that my colleagues on the other side of the aisle, the plaintiffs' lawyers, would say now that we've reached a resolution that it worked for them also.
I would broadly reinforce what Ken just said. I think we have our challenges and we need to solve them, but it's absolutely right to think about these issues in the context of the judicial system as a whole and not any single judge or any single level of the judiciary. I can't help but recall a day last year when we had a patent case that was before a jury in federal court in San Diego. It was a case that we thought we were going to win. If we lost, we thought maybe the damages would be in the single-digit millions. The jury had been out for about 4 days, and I was coming around the corner in the building, and somebody said, "Oh, did you hear the jury came back?" I said, "No, we've been waiting. What happened?" They said, "Well, it was $1.52 billion against us." And I was like, billion, or did you say million? It's like, no, it was billion. And it exemplifies what Chairman Green. And at times it's all about managing risk. But sure enough, there was quickly a clamor among people saying this showed that the system didn't work. The district judge reversed that decision. He granted a decision in our favor, notwithstanding that verdict, and then a week ago, that decision by the district judge was affirmed by the Federal Circuit. So we have a lot of resiliency built into our system. That is one of its strengths, and we just need to ensure that that continues.
If I could just add one point, and this has to do with judicial pay. How long can the system be sustained at either the federal or the state level when the judge can't afford to leave either corporate law or law firms to go into the enticed out because the pay scales are so disparate, and when the law clerks at 1 year out of clerking earn more than their bosses did the year before. I just don't know how long that can be sustained, and we're very lucky that it hasn't the capacity for the bench to handle complex business cases, but I wonder long term.
And I think that is fair to identify as quite probably the single greatest weakness that our federal judicial system has today. We are so fortunate to have a structure, but it does depend completely on persuading truly talented people not only to come do this, but hopefully to do it for the rest of their careers. And the salaries have declined in real terms to such a great degree, and it's worth recalling that decline, they weren't necessarily the most affluent place. I think that if we look ahead 10 or 20 years, we've got to address this problem if we're going to have real confidence in our ability to keep what we have.
I think that's right. I think there is another issue, though. I think in addition to the fact that we have judges who are badly underpaid in both the state and the federal system, we simply don't have enough judges. We don't have enough courtrooms. The system worked for us up until a point, but the fact one cannot expect to go down the road of trying civil cases to juries for very long. I mean, if you just look at the data, you've heard people make reference to the vanishing jury trial. It's in fact a real. And so for those people who really want their day, obviously there are issues on the criminal side just as well. Tremendous pressures placed on people to opt out of the system, to arrange an outcome beforehand. I think that's another issue. We have to provide the resources necessary to have a fully functioning system in this country.
Thank you very much, and a perfect segue into our next panel, which is the alternative dispute resolution the panel on how to settle cases outside the litigation context. But before that, we'll take a brief 10 minutes break, and we'll come back here for the next panel on ADR. Thank you very much.
Good to see you. Nice job. Thank you for guiding us.
You do.
Good directions.
I think we're all Brian. How do you do?